We're diving into a case where frustration and threats boil over. A man threatens violence over a $63 transaction. What could possibly be going through his mind? From a previous history of violence to a new charge of making deadly threats, this is a courtroom battle you don't want to miss. Let's break down what led up to the dangerous words that put him behind bars.
Yes. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. State your name for the record.
Dorian Latrell Murphy.
Dorian, I'm going to ask you some questions. I want you to kind of answer in the direction of the judge, even though I'm standing next to you. She's the one that needs to hear your answers. And of course, when I finish, the young lady to your left, to your right, is going to be allowed to ask a question on behalf of this district attorney's office. Okay?
Okay.
Dorian, do you have any kind of job situation
Yes.
lined up? Would you tell the court about that?
I was working at Komori over there in 1604 in Calabria, along with Bowl and Barrel on near Lock and Terra area.
You said Bowl and Barrel was the second one. What was the first one?
Komori.
Komori?
Yes.
Can you spell that?
Kumori.
What is that
A
exactly?
Japanese cuisine.
Dorian's story starts with a difficult situation, a job as a cook, working hard, but also juggling anger and frustration. After thinking he was wronged by a $63 charge, he lashed out in a big way. It's not just about the money, it's about a man who couldn't control his emotions. The court's about to weigh his past history with violence and his chance at rehabilitation. But does he deserve a second shot?
Sushi and steakhouse.
What kind of work were you doing over there?
I was a cook, a line cook,
How long had you been over at the first place, Komori?
for about 7 months.
And was that a full-time job?
Yes, sir.
So you were a cook, full-time job, making the different dishes that they served over there?
Yes, sir.
Say the location again for us.
I was near 1604 in Calabria.
Thank you. What was the second place? The
Bowl and Barrel over there.
Bowl and Barrel.
And Lock and Terra was a dishwasher.
Okay. What kind of place is that? Is that a big restaurant over there?
It's slash restaurant and then collided with a bowling alley.
Okay, so that explains the bowl part.
Yes,
Okay.
sir.
How long had you been over there?
For 4 months.
And that was a dishwashing job, you said?
Yes, sir.
Now, if you were released to be on probation, is that the type of job skills that you possess as being a cook?
Yes, sir.
And it sounds like are you restricted to just one type of restaurant, or could you go to any other restaurant?
I
And
could
if so,
go-
what would those be?
I could go to different types of locations. I can go to Aston's Creek over there on 1604. I could go to PF Chang's on Lock and Terra. And I believe one more, but I can't remember at the top of my head currently.
How old are you now?
I'm 27.
How long have you been engaged in that type of work?
Since I was 18.
Did you finish high school?
No, sir.
Was that here in San Antonio?
I was homeschooled.
Oh, okay. Now, what kind of support do you have if you're released from jail?
My mother, my grandmother, my uncles, and my aunts.
Are they here in San Antonio?
Yes, sir.
All of them?
Yes, sir.
Now, have you talked to them about it? If you were released, could you just suddenly appear at their door and be able to at least have a place to sleep and eat and report to
Have a
probation?
place to sleep and everything, and then
Here, we get a glimpse into Dorian's remorse. He acknowledges his mistake, but how far does his regret go? When you've had a past filled with violence and impulsivity, like Dorian, can a single moment of reflection undo years of built-up anger? The judge has to consider more than just this one outburst. There's the emotional toll on everyone involved. But when you hear Dorian speak about his newborn and his commitment to change, it becomes clear, he's asking for a chance to prove himself.
potential job opportunities lined up.
So you'd have a phone and everything where you could answer those questions that if you put in an application, you'd be available to get right on those jobs, right?
Yes.
Okay. Do you have transportation?
Yes.
How would that be arranged? Is that you or your mom or who is that?
Currently it would be with my brother.
Okay. To get to the jobs, right?
Yes, sir. If not, then public transportation such as the bus.
So do they live, what part of town roughly do they live in? You're talking about all these restaurants?
Northeast side for my aunt and then my uncle, and then northwest side for my mother and my grandmother.
So some in the proximity of the restaurants that you're referring to, although,
Walking distance, yes, sir.
okay, thank you. Tell us a little bit, this case, you freely entered into a plea on this case. Do you have any remorse? What's your position about what you did
I had a
wrong?
lot of time to think about my actions and know that I need to have a better handle over my tongue, know that there are consequences to my actions as well. All I'm asking for is a second chance. I know what I said and everything was wrong, and definitely took this opportunity as a learning experience.
This was a bunch of threats to a some type of a I don't know. I'm not familiar with it. I know the
The
name.
Cash App chat bot, sir.
Yeah, I don't know how that works, but let's don't get into that. But you were frustrated for some reason. Is that what occurred here?
Yes, sir.
And it was because you thought that something had occurred that you had been
Right.
taken. Excuse me.
My money being taken away from me.
Okay.
But I was mistaken on it. I should have waited and evaluated it before speaking.
Okay. So you deeply regret what happened.
Yes,
You've
sir.
also had a little bit of a history too. We went over that before we ended our plea and everything, right?
Yes, sir.
You seem like you're the kind of person that might not have a drug problem. Do you have a drug problem or not?
Only with
This is where the legal stakes rise. The defendant claims that his threats were a result of his frustration with the system, but that's not going to cut it. In the eyes of the law, threats of violence, no matter the amount of money involved, are a serious offense. The judge is now asking, how do you reconcile a past of violence with the need for rehabilitation? What's the balance between mercy and accountability?
THC weed, but it's not. I've never had a problem. I can go off of it when needed to, and I plan to. I've been clean this long, so
So addiction wise, meth, cocaine.
I don't have any drug problems with
Okay.
those.
So, okay, just the ones that would be of an emotional or a nature that would be a stabilizing type of drug, even though it's illegal, right?
Yes, sir.
And you would be willing to stay off that, correct?
Yes, sir.
The judge would order it if you're on probation. You understand that?
Yes, sir.
No, there would be consequences if you turned up with any of that in your system. Do you understand that?
Yes, sir.
Understand that in the job environment, that might be available. I'm not saying it's in every restaurant, but it might be, you might be around people that would have that and tempt you with that. Would you be able to resist that type of approach? Somebody
sir.
tempting you?
Yes, sir. I would be able to resist and make sure to stick to what I'm needing to keep myself stable and out of jail and doing the things that I need to do to take care of my family.
Is there anything that the judge needs to know that I have not talked about that you feel like Her Honor needs to know?
No, sir.
Okay. You seem very well spoken for someone that, when you say you're homeschooled, but you didn't finish high school, you certainly don't sound like that, in my opinion. Do you read a lot or how
Yes,
do you?
sir. I read a lot. I go to the library occasionally, pick out books. I like to read. Knowledge is power, I believe. So
Thank you. The young lady I spoke to you about, please answer her questions with the appropriate, polite answers and listen to her questions, okay?
yes, sir.
Pass away, Sean.
All right, stay.
Yes, Your Honor. Mr. Murphy, how much money was it that you were so upset over?
I believe around $63 at the time.
$63.
Yes, ma'am.
So you,
And then, we hear the shocking twist. Dorian's own history with violence, an assault charge as a juvenile, comes into play. The judge is questioning whether Dorian can ever truly change, especially when he continues to make dangerous threats like the one about shooting up the store. Even worse, he flaunts his capital murder case, one that had been dismissed. Is this a sign that Dorian hasn't fully grasped the gravity of his actions?
threatened to shoot up a gas station and kill a bunch of people over $63.
Yes, yes, ma'am.
You said that you understand that your actions have consequences. Have you considered how the individuals who were made aware of your threats may have been affected by hearing that you were going to come do that to them?
Yes, ma'am.
And if the roles were reversed, if it had been you that had been threatened by someone that you don't know, who made statements that they were capable, not only were they going to do these threats, they were capable of carrying out these threats, how would that make you feel?
unsafe and not too pleasant, very, very upsetting and troubled.
And you do have a little bit of a history for assault, do you not?
Yes, ma'am.
When you were a juvenile,
Yes, ma'am.
you were placed on deferred adjudication or deferred prosecution for assault public servant
Yes, ma'am.
and assault against a family member.
Yes, ma'am.
Given your history for violence and your apparent short fuse, what assurances does the court have that if she grants you probation, that you won't have a short fuse again and commit an act of violence as we know you're prone to do?
Me doing the time in the bid that I've done now, having a lot of time to think. I also have a newborn, going to be born on November 14th. A lot of other variables from family and just evaluating my life that's going to make sure and ensure that I need to get a tight grip and a tight handle on the situation before I speak and before I act.
Nothing further.
One last question. Going back from today, how long have you been in the jailhouse?
About 4 months now.
Thank you. We have no further questions or witnesses.
I have a couple of questions if there's no objection.
No objection.
Oh, sorry. No.
All right, this is what I'm trying to figure out. Why did you text them and tell them to look my name up on Google for capital murder? So was there ever a capital murder involved?
I haven't Googled him, Your Honor.
And I'm just, what's in the stipulations? You sent message and you said, look my name up on Google for capital murder. So has anyone done that?
I'm thinking there was a charge, but I know it never went anywhere, but I can't remember exactly. I remember asking him about that. And I don't know if that was a mistake. We didn't pursue it because the DA didn't seem to know anything. But I didn't talk to this district attorney about it.
Okay.
But it didn't appear to have anything. I mean, if it was here in San Antonio, I remember that. Is that what you're saying, Joe?
No, I mean, it just says, I haven't Googled anything. I'm just going from the stipulation.
Now, the prosecution is calling out the defendant's failure to report, building the case for a potential probation revocation. The defense pushes back, suggesting a miscommunication or lack of proof. But when you're already in the legal system, one missed check-in can make or break your future. How much leeway does Dorian deserve when his history suggests a pattern of reckless behavior? Is the system too harsh, or is Dorian just getting what he deserves?
No,
I
saw it in their file.
That there was a charge that was dismissed.
Yeah.
Okay. And then, so there was a previous charge against you for capital murder
Yes, Your Honor.
that was dismissed?
Yes, Your Honor.
Okay. And mind you, I'm not taking into consideration that you have a capital murder that's been dismissed because that was dismissed.
Yes, Your Honor.
I'm just going through what's in the stipulations and I'm trying to figure out whether or not you would be appropriate for probation or not.
I understand, Your Honor.
Then, what is this? When I get arrested, the news asks why I shot up the store and everything. I will let it be known that I gave y'all a chance, literally stealing money. So why did you think they had stolen your money?
At the time was when I had swiped my card, it had gave me 2 different transactions. One was not one that I had made.
Mhm.
I tried to talk to the staff at the time.
So what was the transaction for? The first transaction that you think you didn't make?
The $63 one, the one I didn't make, I originally just bought a little vape, maybe like $15-20. Then I was previously, or right after, shortly charged 63, somewhere roughly around the 60s for another charge that I tried to talk to them. They gave me the runaround, and I lashed without thinking and talking.
So what ended up happening to the $630 that you said you were?
Never got it. So,
But it was never charged?
no, it was charged. I'm still negative on it, but I've never got it back. I wound up talking recklessly, and then shortly after I got incarcerated.
All right. Any other questions?
No.
All right, the court will hear argument.
Your Honor, I'll reserve.
Judge, I know this is not real important, but I've represented over a long period of time a lot of people that I thought when I gave them push down the road on probation would probably be back in front of the judge. And this gentleman, since the very beginning when I met him in the jail to now, has acted like he just lost it. And it seems like the kind of his representation of and explanations to me have been much more profound and of depth than the average person that appears, as I've appeared with in courts for many years, where they're just trying to get out of something. I think he just had a really bad slip up. I mean, that's probably not a good way of putting it, but I realize that the only way you can think about it is to wind up with 4 months in jail over $63, but saying a bunch of terrible things over it is pretty bad. I just think from what I've heard him talk about his job history, I didn't know much about that till today. I'm impressed by the fact that I think he can be a contributing member of society. I guess the best part about this guy, when I come back to the beginning of what I began talking to you about my time in this standing here in front of judges, is his insight. I think he's got more insight than the average person that I have over the years, where I thought they were going to be fine. I think stronger about this guy than I thought about them. I think he's figured it out. I think being in jail has probably, I'm guessing, been a real eye opener to Mr. Murphy.
But here's my question. You're 27.
Yes, Your Honor.
How old were you when this occurred?
26.
All right, so you were 26 and you have this juvenile history. Why wasn't that a wake-up call?
Been years since I believe I was 13 or 14.
And then
I was still young, didn't understand. So after here for the time that I've sat and the seclusion from being outside, restrictions on access to things, just really an eye opener.
And let me just tell you, this is my problem. Well, not my problem. This is just something I'm going to tell you. The threats you made, it could have been $63, it could have been $100,000. But according to this, your threat starts at 10. I mean, you're 20, you're in your late 20s. It's not as though you're a teenager.
Yeah.
So they start at 10 and you continue all the way to 105, telling people that you're going to show up at the location, and you put the specific location in there.
This is the moment where the judge has to make a tough decision. Should Dorian go back to prison for a violent outburst over $63, or is probation still a viable option? The balance of justice is delicate here. Dorian's future hinges on the judge's ruling, and we've seen how easily a second chance can slip away when you've got a history like his. Will the judge see enough potential for change, or will the severity of his threats lock him up for years?
It starts with the initial threat they said was, if I don't get my profanity in, say, 3 hours, I'm pulling it up to the store and shooting the place up. And you said it's 10:05 a.m. You got till 1:05 p.m. And then after that, you didn't even give them to the 1:05 p.m. deadline. Then after that, you tell them to look up your name and Google it for capital murder. And I would think that if you had grown from your juvenile days and you know that capital murder has been dismissed, you wouldn't even be bringing that up. But you just like, Google my name with capital murder. And then you come back and say, look, if I don't get my cash back by 1:05 p.m. today, I'm pulling up to that store and I'm shooting the whole effing place up. And then you say, I will crash TF out and go to jail and post this on media. Y'all had a chance. And then when I get arrested and the news asks why I shot up the store and everything, I will let it be known that I gave y'all a chance, literally stealing money.
Yes, Your Honor.
I just don't think you're appropriate for probation. There's the criminal history. Then it would seem that once you're sending these messages, you would step back and think. And then the fact that you have a capital murder dismissed, and mind you, I'm not taking that as true, but for you to say, hey, Google my name with capital murder, like what frame of mind are you in when you do that?
I was out of state of mind for it at the time, Your Honor.
Okay. What I can tell you, I don't think you're appropriate for probation. I don't know if he has any convictions that would preclude him from being eligible for shock probation, because I don't have his complete history, but I'm going to find you guilty. I'm going to sentence you to the 4 years in the prison, give you credit for any time served. There's a $1,500 fine. Time and money will run concurrent. You can't have any contact with any Shell station. And I don't know his criminal history, so.
Are you,
The adult side, Your Honor, I can tell you from what I can see, he has, I just lost my page. I believe he has a misdemeanor theft. Yeah,
Mhm.
he has a conviction for misdemeanor theft and a misdemeanor ABI family.
All right, so counsel, you can, I'll retain jurisdiction.
would you please make a note of that, Your Honor?
Oh, my mind's a steel trap. I'll remember it. Yes.
I may not.
Okay.
That's what I'm saying.
All right, I'll make a note.
Maybe you could let me know, and
Well, I'll retain jurisdiction.
because the court usually asks for a report
Mhm.
in advance, just to alert the court to that.
Okay.
That's why I'm asking about the note.
Yes,
And if the court reads that report and then decides whether to bring him down,
yes.
it's already in the, you know how it works.
Mhm.
Thank you, Judge.
You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you.
Thank you.
You're welcome.
The number that you gave, was it 4?
Yes,
You know, leaving 6 months.
I followed the agreement. All right, defense, the state is asking for revocation. They're asking that your client be sentenced to 10 years in the prison. What are
Judge-
you requesting?
Judge, we're asking that you deny the MTR and terminate his probation. In regards to the facts of the original case, I believe I represented him at the time of his plea, and the complainant was okay with him getting probation. Judge Hilbig gave him probation, gave him jail time as a condition. In between when Mr. Mackey committed his offense and when he pled, Mr. Mackey was shot in the head and almost died. That affected his brain functioning. He had a TBI and went through competency and was competent to stand trial. In regards to this being a second MTR, the state waived the first MTR, so it's not really something that the court we believe should consider. And we asked the court to reconsider that true finding. And the reason we asked that, Judge, is if you review those conditions of probation that are in the court's file, I've never had a contested MTR in which the state didn't either have the probation officer who read him those conditions testify that he signed those conditions, or number two, have someone, a fingerprint examiner, come in and testify that that thumbprint matches Mr. Mackey's thumbprint. The state has failed to prove that Mr. Mackey signed those conditions of probation, that he had knowledge of those conditions of probation, and therefore nothing could be found true because they haven't proved that he is the person who signed these conditions. In addition, what I testified to earlier and what Ms. Fuentes testified to was that there was no testimony or evidence presented by the state that Mr. Mackey knew to report to probation. There's nothing in those conditions that say, if this case gets transferred back to Bexar County, you must report to Bexar County probation. All it says is condition number 5 is report as directed to Bexar County. Well, we know that wasn't an actual condition of Mr. Mackey because he lived in Harris County. He was reporting to Harris County this entire time. Now, if the court still finds that it's true that he violated condition number 5, the court can do so, and we respect that. But we ask the court to review the totality of the case and that they have proven that he failed to report for 1 month out of 120 months. That's 0.8% of the time that they allege that he failed to report. And we ask that you consider what they've alleged and what they've proven and deny the MTR and release Mr. Mackey from this probation.
All right, the court is, as previously stated, the court is finding 5 true, 1 not true, 15 FF not true. The court will find the defendant guilty, grant the motion, revoke. There's an affirmative finding of deadly weapon. And the clerk printed it out. I couldn't find it either. I'm trying to see because I'm not the one who did the plea. The previous.
Are you looking for the plea bargain, Your Honor?
I have the plea bargain, but there are no mention of no contact or I'm sorry, there are no mentions of any no contact orders. So I'm sorry, counsel, do you have the trial court certification?
I haven't had him sign it yet, Judge. I need to explain to him.
There's to be no residing in any households with minors. And the court will sentence you to 6 years in the prison, give you credit for any time served. Is there anything else?
We ask for findings in fact and conclusions of law.
Sure. And have you gone over the trial court certification?
I have not, because
All right, if you'll go,
he needs time to understand it.
yes, okay. And then just come back and I'll finish.
But I believe it should be 2014.
Okay, so here's the thing. Y'all need to slow it down because the court reporter has to take everything down and everyone is going to have to raise your voice.
Rick Painter for the state of Texas.
For the
Kelly Piddle for Joshua Mackey.
And are you Joshua Mackey?
That's for Mackey.
All right, and let me see here. And is the date on the motion to revoke, what is the date you all have for when it was filed?
There's 2, Your Honor. The original motion to enter adjudication of guilt was from February of 2025.
Just one moment. Probation, can I have a copy of the motions to revoke?
Yes.
Because I don't have the right filing date.
While I don't know if the one that you do have though is state supplemental motion, which was from March of this year.
I don't have any of that.
Okay.
One, I think, Judge.
Okay. All right. Are you the same Joshua Mackey who was placed on deferred adjudication in 2014 CR 5495 for the offense of aggravated assault with a deadly weapon on April 6, 2015 for a period of 10 years? Is that you? And have you had a chance to review the motion to enter adjudication of guilt and revoke community supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney? These documents, have you reviewed those?
We've reviewed each other.
All right. Have you had a chance to review those with your attorney?
Yes.
You didn't say yes or no?
Yes.
All right. Do you understand them? All right, state.
Before we continue, Your Honor, maybe go off record for 1 second.
Sure.
If we're going to proceed with the contested, one of our witnesses is a Harris County probation officer who is on the Zoom. I want to make sure that defense is okay with us proceeding that way.
We're going to object under the Sixth Amendment and due process.
They say they're going to object to your witness appearing by Zoom.
In that case, Your Honor, we would ask for a recess so we can have her available to come and drive in to testify in person.
All right, just one moment. And who is this? Is it Jessica Herron?
Yes, Your Honor.
Not responding.
Yes.
We were set on this case last Monday when the court set it for contested.
Mhm.
It's my understanding, and the state can correct me if I'm wrong, they subpoenaed the witness sometime this morning between 10 and 11 a.m. Knowing that we were set for the contested this morning, we ask that you deny their continuance.
All right, the court will recall this case. The court will recall it for 3:30.
Okay, may I, okay, 3:30. Okay.
All right. So, Officer Herron, we'll need you in Bear County. The defense has objected to your appearance by Zoom. So I'll need you here by 3:30.
I'm in Harris County.
And is that Houston?
Yes, ma'am.
All right, so what is the drive time from Houston to here?
Like 4 hours.
All right, so we'll have you here then by 4:30. Is that possible?
I have to see because I have to pick up my son from daycare as well.
Uh, all right, just let us know.
Yes, ma'am.
If it doesn't work out, Your Honor, can we get it reset until Monday?
No.
So let's see where we are at this afternoon. So everyone is to come back in the afternoon.
Okay.
What time, Judge?
Let's say 4:30. I don't know what the issues are in Houston. And Officer Herring, if
Yes, ma'am.
you're able to be here well before then.
I have to speak with the supervisor about it because I didn't know I was gonna be needed in Barry County.
Okay. All right. I'll probation. I'm sorry. The state and the defense will be able to speak with you probably. All right.
Yes, ma'am.
All right, and they'll let me know something. All right. Thank
Can
you.
you ask her if she comes? I want her to bring her complete file.
We do have the probation officer in their account here. Is there any way that we can proceed with her testimony so that?
Yes.
We can get her out of the way, yes. and come back
Yes.
for hers.
So he needs to go on the record on whether he's pleading true or not true. All right. Thank you so much, Officer Herring.
No problem.
All right. You may proceed.
Yes, Your Honor. Violation condition number 5. In Bear County, Texas, the defendant, Joshua Mackay, did then and there fail to report to the supervision officer as directed for the month of March 2025 in violation of condition number 5.
Are you plead to that true or not true?
Not true.
State?
May I call witness, Your Honor?
Well, I mean, are you going to read the other violations?
Yeah, yes, I'm sorry.
No problem.
Okay. Violation condition number 1, on or about the 7th day of February 2025 in Harris County, Texas, the defendant, Joshua Mackay, committed the offense of assault in violation of condition number 1.
Are you plead to that true or not true?
Not true. Violation condition number 15FF. On or about the 31st day of January 2025 in Harris County, Texas, the defendant, Joshua Mackay, did then and there fail to register for, attend an outpatient treatment program in violation of condition number 15FF.
Are you plead to that true or not true?
Not true. The state will waive the other violation, Your Honor.
Any objection to the waiver of 10D?
No.
All right, state, you may call your witness.
Yes, Your Honor. At this time, state would call Miss Jessica Fuentes.
All right, if you'll stand here, please. So could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand, state your name for the record.
Jessica Fuentes.
All right, state, you may proceed.
Thank you. Good morning, Ms. Fuentes. How are you currently employed?
I'm employed with Bear County CSCD,
And what does CSCD stand for?
Community Supervision and Corrections Department.
And what are some of your normal duties and responsibilities? Oh, excuse me, strike that question. What is your current job title with them?
It is Assistant Probation Officer.
Okay, what are some of your normal duty and responsibilities in that position?
I supervise cases that transfer out of state and out of county. So most of my contact is with states and counties.
Okay. During the course of your work in that position, did you have an occasion to come into contact with a case involving Mr. Joshua Mackay?
Yes.
How did you come into contact with that case?
The case was assigned to me in July of 2020.
Okay, what happened when the case was assigned to you in July of 2020?
He was on supervision with Harris County.
Okay, and once you became aware that he was under supervision in Harris County, what did you do at that point?
Notified Harris County that I was the new assigned officer.
So from that point in time, did you have any further interaction, or was all his supervision from that point with Harris County?
Everything from that point was from Harris County.
Okay. Did the probation officer in Harris County check in with you every now and then regarding this case specifically?
They sent me a report in, I believe, January.
What happened after you received that report?
I was taking note that he has.
We object to hearsay, Judge.
Sustain.
Without saying specifically like that, what was your involvement after you received that?
I was notified of its progress.
Okay, and were you notified of any type of successful completion of his probation from Harris County?
No,
And object to hearsay again, Judge.
Right, that'll be sustained.
To your knowledge, has Mr. Mackay successfully completed, in your review of your own case file, his probation?
Object to hearsay.
Sustained.
She can testify about her own review of her own case file, Your Honor.
The objection will be sustained.
To your knowledge, is Mr. Mackay still currently on probation?
yes,
To your knowledge, does he have conditions that remain outstanding?
yes.
Object to hearsay.
That'll be overruled.
To your knowledge, what are some of the conditions that he has outstanding?
Object to hearsay, Judge. She's testifying from her knowledge from a document, not an evidence.
You all make your legal objections. I'll respond to
Sure.
the legal objection. Your objection is the hearsay.
Hearsay, lack of personal knowledge.
Right, that will be sustained.
In your general course of working in your current position, are probationers required to check in regularly with the probation department?
Not with their tongue.
Not
Do
with-
you mean with the,
I'm not talking about this case anymore. I'm talking about in general. And to your knowledge, in your current position and in your experience as a probation officer of Bear County, is one thing that all probationers have to do is to check in regularly.
yes,
Okay. Your knowledge, did Joshua Mackay ever check in with you regularly?
Object to hearsay.
That'll be overruled with regards to whether or not he checked in with her.
Did he ever check in with you regularly?
no,
Was he required to check in with you regularly?
no,
At any point in time after his probation from Harris County stopped being monitored, was he required to check in with you?
Yes.
When was he required to check in with you?
as soon as this. case
An
was-
object to relevance. An object to relevance. It's not.
Overruled.
You may answer the question.
As soon as this case was returned to Bear County
To your knowledge, when was this case returned to Bear County?
in March of.
Object to hearsay.
Overruled.
And what was the response? I'm sorry?
March of 25.
What happens in March of 25 when the case was transferred back to Bear County?
He was to either report by calling or in person.
Did he ever report to you over the phone
No,
in March of 2025?
no,
Did he ever report to you in person in March of 2025?
no.
After he did not report to you for the month of March of 2025, what did you then do?
I submitted a supplemental MTR with failure to report for the month of March.
We have just a brief moment, Your Honor.
Yes.
Thank you. No further questions at this time. I'll pass the witness.
Can I have the court summary? You said your name was Miss Fuentes? Okay. Did you bring the chronologicals for this case?
Not printed out.
Do you have any proof to the court that Mr. Mackey was advised to report to Bear County other than your testimony today?
No, I don't.
You have any proof that Mr. Mackey was notified that his case was transferred back to Bear County? Do you have any proof of that?
I don't have proof of that.
That's what it is.
Just one question, if I may, Your Honor.
Yes.
Ms. Fuentes, you were asked by the defense about the Cronus that I guess you didn't bring with you. Would you have the ability to print that out at this time?
Yes,
Okay, and Your Honor, would Your Honor allow a minute for her to do so? That's my only question.
So any other questions of this witness?
Of this witness, yeah.
Any
No.
other questions? All right. So then that will leave, oh, sorry, you may be excused.
Okay.
That will leave the witness from Harris County. But since the court has received testimony on violation of condition number 5, does anyone wish to argue with regards to whether that is true or not true, or what the evidence showed?
I can make an argument, and then I guess defense can make his argument if that's okay.
Yes.
Yes, Your Honor. At this time, as you know, the burden of proof at these types of hearings is by preponderance of evidence. You heard testimony from the witness that while the defendant was not directly under her supervision, he was in Harris County being supervised out there. Once his case got transferred back to Bexar County, he was required to check in with his Bexar County probation officer, and he failed to do so. He never called. He never reported in person. He knows and should know throughout the 10 years that he's been on probation that that is one of his normal duty responsibilities as a probation officer, to check in with the probation officer. So upon him being notified that he was being transferred back to Bexar County from Harris County, he should have checked in. He didn't check in, and we feel that that violation has been proven today, Your Honor.
All right, defend.
And we would ask also, I'm sorry to interrupt, the court to take judicial notice of the court file for this case.
Judge, they have to prove that he knew to report to Bexar County. There's no testimony from this probation officer that he was advised that he was to report to Bexar County, or that his probation was transferred back from Bexar County. So they haven't proven that allegation based upon the testimony of their own officer.
All right. The court is going to find violation of condition.
Okay, sorry.
Condition number 5 true. The court will await the witness from Harris County, if the witness from Harris County is able to appear, to hear any testimony, if there is any testimony with regards to violations 1 and 15 FF.
Okay. I want to keep Ms. Fuentes subject to recall.
All right, Ms. Fuentes, you're subject for recall. Somebody needs you back here this afternoon. All right, is there anything? And is she allowed to appear by Zoom, or you want her
No,
in person?
she's got to be here.
All right, so they're requesting that you be in person. All right.
Will the court withhold their finding as to condition number 5 until both sides have had an opportunity to present its case?
The court has found violation of condition number 5 true. If for some reason there is a testimony that is presented that causes the court to reconsider based upon any other evidence, the court will of course reconsider.
Okay.
All right.
Thank you.
Thank you.
What time did you say?
Probably 4.
Okay.
All right. Anyone else ready?
David Castro from the very, very last case.
In the end, the judge rules that Dorian is guilty of violating probation, sending him to prison for 4 years. The court is clear: threats, no matter how small the amount of money, can't be taken lightly. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.